Time the New York Attorney General's major investigations.
Ms. Sanders, 18 counts, grand larceny, forgery, money laundering, 3 Queens homes stolen from elderly owners, over $1 million funneled.
There are two versions of Stacy Saunders. The licensed mortgage broker her clients trusted to guide them through the most important transaction of their lives, and the one named on a federal indictment for stealing homes from elderly New Yorkers who didn't even know their properties were being sold. Both are the same person.
I marketed properties that were brought to me. You want to talk about who identified those houses and who put those people at the closings? Go find Marcus Wilker. I was the broker, not the forger.
3 homes, more than $1 million. 5 people working in coordinated roles for 13 months to steal generations of black family wealth from the streets of Jamaica and St. Albans, Queens. By the time the New York Attorney General's Major Investigations Unit finished cataloging the evidence, the woman in this footage would be the only defendant to take her case to trial. The jury would convict her on every single count, 18 out of 18. Grand larceny, attempted grand larceny, forgery, criminal possession of a forged instrument, money laundering. A former mortgage broker who knew exactly how the system was supposed to protect homeowners, and who used that knowledge to teach 4 other people how to take everything from people who could no longer fight back. Before we get any deeper into this one, I have to ask, do you know whose name is currently on the deed to your house, or your parents' house, or your grandmother's house? Most people don't. Drop a comment and let me know whether you've ever pulled your own property record. And if you're not subscribed yet, hit that button now. We cover the cases that take real family wealth and turn it into someone else's payday. And this channel doesn't let those stories disappear. Stacy Saunders was born in 1973 in Hollis, Queens, on a block of brick row houses where every front porch had a folding chair and every kitchen had a stack of mail addressed to the same family for 40 years. Her mother worked overnight shifts at Queens Hospital Center as a unit clerk. Her father drove a city bus for the MTA out of the Casey Stengel Depot in Flushing. They bought their 2-family home on 199th Street in 1971 for $19,000, a number they would repeat at every family gathering for the next 3 decades as proof of what a working-class black family could build in New York City if it held on long enough. Stacy was the middle of 3 children. Her older brother went into the Navy at 18. Her younger sister became a public school teacher. Stacy, by every account from neighbors who spoke to investigators years later, was the smart one. The one who read the newspaper at the kitchen table while her mother fried whiting for breakfast. The one who could explain a credit card statement to her grandmother in language her grandmother could actually use. The one who, at 14, sat next to her father at the dining room table and helped him fill out the paperwork to refinance the family home, and remembered, for the rest of her life, the specific shape of the questions the bank had asked, and the specific way her father's hands had gone still when he did not understand one of them. She graduated from August Martin High School in Jamaica in 1991, ranked in the top 15% of her class, with a guidance counselor's note in her permanent file that read, "Capable of significantly more than she currently demonstrates." She enrolled at Queens College that fall, commuted on the Q25 bus, paid her tuition with a patchwork of Pell Grants, a part-time job at a Sleepy's mattress store on Hillside Avenue, and the small contributions her parents could make between mortgage payments. She majored in economics. She graduated in 1996, a year later than her cohort because she had taken a semester off to help her mother recover from gallbladder surgery. Her first job out of college was as a loan processor at Greenpoint Savings Bank, a since-defunct institution that had been one of the largest thrift banks in New York. She made $28,000 a year. Her performance reviews from those years, recovered later from old personnel files when investigators went looking for her professional history, used phrases like meticulous with documentation, shows unusual aptitude for the regulatory side, and consistently exceeds expectations on file accuracy. She moved from loan processor to junior underwriter inside of 2 years. By 2001, she had earned her mortgage broker's license through the New York State Department of Financial Services and was working at a brokerage on Sutphin Boulevard in Jamaica that specialized in first-time buyer mortgages for families in the surrounding zip codes. She was good at it. The community knew her. She wore charcoal pantsuits and pearl studs and carried a leather portfolio with her business cards in a side pocket. And she spent her days walking elderly Queens homeowners through refinance options, explaining what an escrow account was, sitting at kitchen tables in St. Albans and Cambria Heights and Springfield Gardens with her shoes off and a glass of water in front of her, drawing out amortization schedules on the back of envelopes for women in housecoats who had owned their homes since the Lindsay administration. She married in 2003. Her husband was a Parks Department maintenance supervisor named Wendell. They bought a small house in Hollis Hills, 3 miles from where Stacy had grown up, with a 30-year mortgage at 5.25% and a backyard barely big enough for a folding table and 2 lawn chairs. They had no children. They had a tabby cat named Marvin. They had season tickets to the Jets when the Jets played at the Meadowlands. They had a routine. For 7 years, by every visible measure, Stacy Saunders was exactly what her guidance counselor had hoped she would become. She underwrote mortgages. She served on the membership committee of the Hollis Civic Association. She volunteered at the annual Jamaica Avenue cleanup. She was the woman at the family barbecue who would notice when an elderly aunt's prescription bottles were getting confusing, and who would sit down the next weekend with a notepad and help sort them out. And then 2008 arrived. To understand what Stacy Saunders eventually did, you have to understand what she knew about the system she would later exploit. New York City's property recording system is administered by the Department of Finance, which maintains the official record of every deed, mortgage, lien, and transfer for every parcel of land in the 5 boroughs. The system traces back, in some neighborhoods, to records older than the United States itself. The deed to a Queens house is, in legal terms, the document that establishes ownership. Whoever holds the most recent valid recorded deed owns the property. Whoever can produce a recorded deed transferring that property to someone else has, on paper, transferred it. The system was designed around an assumption, the assumption that the person showing up at a closing to sell a house is the person who owns the house. The closing process, the title search, the recording fee, the notarization, the title insurance, all of it presumes that the seller is who the seller says they are. The verification layer is thin: a driver's license, a social security card, a signature, a notary who watches the signature happen and stamps a seal. That is the architecture. That is the entire architecture. For a community like Southeast Queens, the deed is not paperwork. The deed is the family. Jamaica, St. Albans, Hollis, Cambria Heights, Springfield Gardens. These neighborhoods built one of the most consequential repositories of black homeowner wealth in America between the late 1950s and the early 1970s. Families that had been locked out of mortgage credit in other parts of the city found their way into these neighborhoods, bought small brick homes with hard-won FHA loans, paid them down across 30 years, passed them to their children, and in many cases passed them again to their grandchildren. By 2019, when this story really begins, large numbers of those homes were owned on paper by people who were 90 years old, 95 years old, or who had been dead for some time without their estates being properly transferred. Those homes, owned on paper by elderly or deceased people, often physically vacant, sometimes still containing the original owner's furniture, sometimes occupied by an adult child who had never bothered to file a probate petition, were what the people inside the brokerage business called sleeping assets. The taxes were getting paid usually. The utilities were getting paid usually. The mortgage, if there was one, was either paid off or so old that no one was paying close attention. The legitimate owner was in a nursing home in the Rockaways, or in the hospital, or in a cemetery in Pine Lawn. The Department of Finance does not, as a matter of routine practice, verify that a person selling a New York City home is alive. It does not verify that the signature on a deed transfer matches the signature of the person whose name is on the prior deed. It does not cross-reference closing identification documents against state DMV records. It does not require fingerprints. It does not require photographs of the seller at the closing. It accepts what the title company submits, and it records what it accepts, and the recording becomes the new legal reality. A former mortgage broker, sitting in her dining room in Hollis Hills with her laptop and her professional license number, knew every gap in that system. She knew which title companies asked the most questions and which ones asked the fewest. She knew which closing attorneys ran their offices like factories and which ones actually looked at the seller's face. She knew that the entire system rested on the assumption that the person across the table from the notary was who they said they were. And she knew exactly how much that assumption was worth, in dollars, if you were willing to violate it. The operation did not start as a 5-person ring. It started as a conversation in the spring of 2019 between Stacy Saunders and a man named Marcus Wilcher, whom she had met years earlier through the loose social network of the Queens real estate business. Wilcher was 47, charismatic, and had spent most of his adult life on the margins of legitimate property work, flipping houses sometimes, fronting for absentee landlords other times, brokering off-the-books cash transfers between people who had reasons not to use traditional financing. Wilcher had identified a house. The address was 161-14 121 Avenue in Jamaica. It was a 2-story brick home with peeling paint on the trim, a buckled front walkway, and an interior that had not been updated since the mid-1980s. The legitimate owner was elderly, in declining health, and was no longer living in the home. The property taxes were current. The mortgage had been paid off years earlier. On paper, the home was free and clear. Wilcher's proposal to Saunders, according to evidence the prosecution would later put before the jury, was straightforward. He would identify the targets. She would handle the marketing, finding investor buyers willing to purchase the homes at below market prices, no questions asked, in fast cash equivalent closings. She would use her industry knowledge to navigate the title and closing process, to anticipate which title companies would push back and which would not, to draft the contracts in a way that did not raise flags. They would need other roles filled. Someone to manufacture the forged identification documents. Someone, actually 2 people, to physically appear at the closings, present those forged documents, and sign the deeds in the legitimate owners' names. Wilcher recruited Anyakacha Hercules, 47, who had a prior fraud history and who could produce convincing forged driver's licenses and social security cards. He recruited Jerry Curran, 66, from the Bronx, to serve as one impersonator. He recruited Dean Lloyd, 61, from Pennsylvania, to serve as the second. The first closing happened in September of 2019. The target property was 161-14 121 Avenue. Wilcher had compiled the legitimate homeowner's information, full name, date of birth, social security number, and a clean signature sample obtained from publicly available filings. Hercules used that information to produce a New York State driver's license, bearing the homeowner's name and date of birth, but Jerry Curran's photograph. She produced a matching social security card. Saunders had identified an investor buyer. The buyer was offering substantially less than what comparable Queens homes were selling for that month, but the deal was clean cash, no contingencies, fast close. The investor's lawyer requested the standard documentation. The title company conducted the standard search. Nothing in the recorded history of the property suggested anything other than a normal sale. On closing day, Curran walked into the title company's office on a side street off Queens Boulevard. He wore a button-down shirt and slacks. He presented his forged driver's license to the closing attorney. He sat down at the conference table. He signed the deed transfer, the seller's affidavit, the title insurance application, the closing statement, the bill of sale for the personal property remaining in the home. He used the legitimate owner's name on every signature. The notary watched him sign. The notary stamped the documents. The closing concluded. Curran walked out with a check. The check was deposited into a newly opened bank account that had been set up in the legitimate owner's name, using the same forged identification documents at a branch where no one had ever met the real owner. The second sale happened a few months later. The property was 112-39 176th Street, also in Jamaica. Dean Lloyd played the impersonator that time. The same script, the same documents, the same below-market price to a different investor buyer, the same flow of funds. The third sale, in 2020, was 168 11 119 Avenue. By that point, the ring had refined the process. They had a working forgery template. They had 2 interchangeable impersonators with experience presenting themselves at closings without setting off alarms. They had a structure of LLCs and bank accounts that allowed them to receive the proceeds, run them through several entities, and pull them out as personal compensation. One detail from this third property would become important later. To bolster the sale's legitimacy, Curran submitted a sworn affidavit identifying himself not as the homeowner, but as a longtime family friend of a separate property's owner, vouching for the legitimacy of a parallel transaction. They had stopped merely impersonating sellers and had begun fabricating supporting characters in their own paper drama. By the end of 2020, more than $1 million in proceeds had moved through the ring's accounts. The 3 legitimate homeowners, or, in some cases, their adult children and grandchildren who held a legitimate ownership claim through inheritance, had no idea any of this had happened. Their families were not getting the property tax bills anymore. Their families were not getting the utility notices. But the families had not been getting those bills in a while because the legitimate owners had been hospitalized, or had been in a nursing home, or had passed. The signal that something had changed did not reach them, not for months. The catalyst came from inside one of the families. In the fall of 2020, the granddaughter of the elderly owner of one of the 3 properties, a woman in her late 30s who worked as a registered nurse in a Long Island hospital and who had been her grandmother's primary caregiver in the final years of her grandmother's life, sat down at her kitchen table in Valley Stream with the previous year's stack of unopened mail. Her grandmother had passed several months earlier. The probate process had not yet been completed. The granddaughter was working through the estate paperwork piece by piece, evening by evening, after her shifts. She opened a notice from the New York City Department of Finance. The notice was addressed to her grandmother's house at the Queens property. The notice was a routine confirmation of a recorded deed transfer. The deed had been transferred several months earlier. The seller, according to the recorded document, had been her grandmother. The signature on the recording, according to the form, matched the name. The sale had been to an investor buyer the granddaughter had never heard of, for a price that was a fraction of what the home was worth. Her grandmother had been physically incapable of leaving her bed for the last 14 months of her life. Her grandmother had not signed anything in that period. Her grandmother had not appeared at any closing. The granddaughter called her cousin. The cousin called an attorney. The attorney called the office of the New York State Attorney General. The complaint was routed, in due course, to the Major Investigations Unit, and from there to a detective supervisor named Anna Ospanova, who had been working a portfolio of suspected deed theft complaints out of Queens for some time. Ospanova pulled the recorded deed. She pulled the closing file from the title company. She compared the signature on the recorded transfer to authenticated samples of the grandmother's actual signature, drawn from old bank records and tax returns. The signatures did not match, not even close. She pulled the photocopy of the driver's license that had been used at the closing. The name on the license was the grandmother's. The date of birth was the grandmother's. The photograph was a man, and the man was not anyone in the grandmother's family. Ospanova checked the second of the 3 properties. Same pattern, different forged driver's license, different impersonator photograph. She checked the third property. Same pattern, different impersonator again. But each impersonator's face was the same as one of the other 2. The ring had only 2 impersonators. They were just rotating them. By the spring of 2021, the Major Investigations Unit understood what it was looking at. Not a single act of fraud against a single family. Not an opportunistic impersonation. A business. A coordinated operation with a target identifier, a marketer, a document forger, and 2 impersonators. A business that had been running for 13 months. We're heading into the investigation now and then into the trial. If you have made it this far, you already understand why this case matters more than most. It is the case that shaped the law every other deed theft prosecution in New York would follow. If you want more coverage like this, cases that explain how organized fraud actually works and how the system caught up to it, subscribe and stay through to the end. The verdict in this one is the kind of moment people remember. The investigation that Detective Supervisor Anna Ospanova and the Major Investigations Unit conducted between the spring of 2021 and the December 2022 indictment was a documents case. It was not a wiretap case. It was not a confidential informant case. It was a case built, piece by piece, from the paper trail that the ring itself had left behind. The team pulled every closing file for every transaction at the 3 properties. They pulled the bank records for every entity and LLC that had received funds. They pulled the corporate filings for those LLCs and traced the registered agents, the addresses, the signatories. They pulled the application records from the bank branches where the imposter accounts had been opened, and they cross-referenced the staff who had processed those applications against the photographs on the forged identification documents. They traced the money. More than $1 million in proceeds had flowed out of the 3 closings into a network of accounts that, on paper, were owned by elderly Queens homeowners who had never visited those banks. The money had moved from those accounts into LLC accounts. From those LLC accounts, it had moved into personal accounts. The personal accounts belonged to Wilcher, Saunders, Hercules, Curran, and Lloyd. The forged identification documents were the spine. For each of the 3 properties, the prosecution could assemble a side-by-side comparison. On the left, the legitimate driver's license of the homeowner, pulled from DMV records. The name, the date of birth, the address, the photograph of the actual owner. On the right, the forged driver's license that had been presented at the closing. Same name, same date of birth, different photograph, the photograph of the impersonator who had appeared. The 2 licenses were nearly identical except for the face. The forgery was good. It was good enough to pass the casual look of a closing attorney. It was not good enough to survive comparison against the real document. The signatures were the second layer. The team pulled signature samples of each legitimate homeowner from authenticated sources: bank signature cards, prior recorded deeds, will documents, tax returns. They placed those samples next to the signatures on the fraudulent closing documents. The signatures on the fraudulent documents did not match. Forensic document examiners produced reports describing in granular detail the pen pressure differences, the letter formations, the spacing patterns that indicated the signatures had not been produced by the same hand. The closing day surveillance was the third layer. The title companies where the closings had occurred had security cameras. The footage from the closing dates survived. The footage showed Jerry Curran and Dean Lloyd walking into the title company offices on the relevant dates, sitting at the closing tables, signing the documents. Their faces were on the footage. Their faces were also on the forged driver's licenses. The match was complete. The Curran affidavit, the document Curran had submitted in a separate transaction, posing as a longtime family friend of a different homeowner, sealed the conspiracy charge. It demonstrated that the ring's impersonation strategy went beyond the closings themselves. It demonstrated coordination. It demonstrated that Curran was not merely a hired hand for a single closing, but a recurring participant in a larger structure. And at the center of the documentary record, repeatedly, was Stacy Saunders. Her name on the marketing communications. Her email exchanges with investor buyers, advising them on which entities to use, which timelines were realistic, how the title insurance would clear. Her professional knowledge, the mortgage broker's understanding of where the verification gaps were, embedded in the very design of how the closings had been structured. The indictment came down in December of 2022. 5 defendants, 18 counts each in the original count structure. Grand larceny in the second degree, attempted grand larceny, forgery, criminal possession of a forged instrument, money laundering. The morning Stacy Saunders was arrested, she was in the kitchen of her Hollis Hills home making coffee. It was just after 7 a.m. Her husband had already left for an early shift at the Parks Department. Marvin the cat was asleep on a chair. The investigators who came to the door identified themselves as agents of the New York Attorney General's office and presented the warrant. "Stacy Saunders, we have a warrant for your arrest. You need to come with us." She stood in the kitchen with the coffee pot in her hand for a full beat before she set it down on the counter. "On what charge?" "Grand larceny, forgery, money laundering. The indictment is from Queens County. You can read it in the car." "I think there's been a mistake." "Ma'am, we have signed and recorded closing documents from 3 property transfers in Jamaica and St. Albans. We have the wire records. We have the bank accounts opened in the names of homeowners you knew personally. I would advise you to speak to your attorney before saying anything else." "I have a professional license. I have been a mortgage broker in this city for 20 years. There is a mistake." "Ma'am, please put your hands behind your back." She did not resist. She did not raise her voice. She turned and let them place the cuffs. Her hands, the lead investigator noted later, were not shaking. Her face had gone very still. Her eyes were on the corner of the kitchen counter where her professional license, framed, was hanging on the wall above the cookbook shelf. "Can I tell my husband?" "He's already been notified. He's on his way back." They walked her out the front door of her own house in handcuffs at 7:17 in the morning. The neighbors were beginning to come out for the day. A retired postal worker across the street was walking his dog. The dog stopped at the curb and watched. Stacy Saunders did not look at any of them. She got into the back of the unmarked car. The car drove away. 3 hours later, at her arraignment in Queens County Supreme Court, she entered a plea of not guilty. She would be the only one of the 5 defendants to maintain that plea all the way to a verdict. The other 4 defendants resolved their cases through guilty pleas across 2023 and 2024. Marcus Wiltshire pleaded guilty to grand larceny in the 2nd degree on May 23, 2024. At his sentencing in July of 2024, the prosecution made clear that Wiltshire's role was not limited to the 3 properties charged in the December 2022 indictment. The court accepted evidence that he had been involved in the theft of 2 additional Queens properties beyond what the indictment had captured. The judge sentenced him to 3 to 9 years in state prison. Anyakacha Hercules, who had a prior fraud conviction in a separate matter, was sentenced to up to 3 years for her role producing the forged driver's licenses and Social Security cards. Jerry Curran pleaded guilty to filing false instruments. Dean Lloyd pleaded guilty to filing false instruments. Their sentences reflected their roles as the operational hands of the scheme rather than the architects. Stacy Saunders went to trial.
Wait, you don't write anything down after conversations?
This is Pocket. I never go anywhere without it.
The trial began in May of 2025 in Queens County Supreme Court and lasted 2 weeks. The prosecution called more than 20 witnesses. Title company employees who had handled the closings, bank employees who had processed the imposter account openings, the granddaughter of the deceased homeowner whose Department of Finance notice had triggered the investigation, Detective Supervisor Anna Ospanova, who walked the jury through the document-by-document reconstruction of the conspiracy. The defense's theory was that Saunders had been a mortgage and marketing consultant, operating in good faith, and that any criminal intent had belonged to Wiltshire and the others. The defense argued that her communications were professional, that her involvement in the marketing of the properties did not establish her knowledge that the sales were fraudulent, that she had been used by Wiltshire without understanding what he was doing. The prosecution put the documents in front of the jury, email after email, spreadsheet after spreadsheet, the bank records, the LLC filings, the closing communications, the fact that Saunders had personally known one of the legitimate homeowners through her years working in Southeast Queens, the fact that the timing of the marketing communications aligned precisely with the timing of the impersonations, the fact that Saunders' professional expertise, her detailed mortgage broker's understanding of title insurance, closing procedure, and the verification weaknesses in the property transfer system was reflected in the structural choices the ring had made at every closing. The The jury deliberated for less than a full day. They returned on every count, 18 out of 18. Grand larceny, attempted grand larceny, forgery, criminal possession of a forged instrument, money laundering. Each count was read aloud in the courtroom. Each count came back guilty. The sentencing was scheduled for June 11th, 2025. Her maximum exposure under the statutes she had been convicted of was 5 to 15 years in state prison. The granddaughter of the deceased homeowner, the registered nurse who had opened the routine notice from the Department of Finance at her kitchen table in Valley Stream and realized what had been done to her grandmother, gave a victim impact statement at the sentencing. She spoke about the house her grandparents had bought in 1968, the house where she had spent every Sunday of her childhood, the house where her grandmother had passed in the upstairs bedroom that overlooked the small yard with the rose bush her grandfather had planted. She spoke about the years of civil litigation that her family was now facing to try to reclaim the deed from the investor buyer who had purchased the property in good faith. She spoke about the second mortgage her family had taken on her own home to pay the attorneys. She spoke about how the deed to a house in Southeast Queens, for a black family in her generation, was not a piece of paper. It was the largest thing her grandparents had ever built. It was the only thing. The judge, before imposing sentence, addressed the courtroom. He spoke about the difference between a single act of fraud and a coordinated business of fraud. He spoke about the specific harm done when the system of property recording, the system the state of New York had operated for centuries to protect ownership, was exploited by people with professional knowledge of how that system worked. He spoke about the fact that Stacy Saunders had not been a hired hand. She had been a mortgage broker. She had held a license issued by the New York State Department of Financial Services. She had walked elderly Queens homeowners through refinances at their own kitchen tables for nearly a decade before she had decided to put that same knowledge to a different use. He spoke about the families, the 3 Jamaica and St. Albans families, the grandmother who had owned her home for 52 years, the retired postal worker whose estate had been the target of the second sale, the disabled veteran whose property had been the third. The Wiltshire Saunders deed theft ring became the foundational case in the New York Attorney General's sustained deed theft enforcement priority. The April 2023 state legislation that strengthened the legal tools available to victims of deed theft drew directly on what this investigation had documented. The Bronx Campbell case in 2024, the Queens Martinez case in 2025, the Bronx Guevara Francis case later in 2025, each one followed the operational template that this investigation had first exposed. The Department of Finance began reviewing the recorded deeds from the same 2019-2020 window for similar patterns, asking the structural question that the case had forced into the open. How many other deed transfers, filed during the same period, had been the products of similar schemes that had simply gone undetected? 3 families in Southeast Queens continue, as of the writing of this account, to fight in civil court to reclaim the homes that had been stolen from them. The criminal courts delivered the accountability. The civil courts are still delivering the restoration. The Hollis Hills house was put on the market within 90 days of the conviction. The husband moved to a 1-bedroom rental in Bayside. Marvin the cat went with him. The professional license that had hung framed above the cookbook shelf in the kitchen for nearly 20 years was, in the final accounting, the most expensive thing in the room, not because of what it had cost to earn, because of what it had taught her about how to break the very thing it had been issued to protect. The house her own parents had bought in Hollis in 1971 for $19,000. The house she had grown up in, the house where she had sat at 14 at the dining room table helping her father with his refinance paperwork, was still owned by her younger sister, the schoolteacher, who had taken it over after their mother passed in 2018. The sister, in the months after the verdict, did one thing she had not done before. She drove to the borough president's office and filed for a duplicate copy of the recorded deed. She had it framed. She hung it on the wall in the dining room, above the chair where their father had once sat, with his hands going still over a question he had not understood. This case was foundational. But the case on the right-hand side, built on what this one started, and what those defendants did to their victims, is somehow even harder to watch. Click it now.